Before we get started, hit that subscribe button and like this video. We bring you detailed analysis on key events that most media skip. Now, here's what happened. Yesterday, what unfolded inside the congressional hearing room left Supreme Court Justice Brett Kavanaugh visibly shocked, while the entire legal world kept talking. It happened as Congresswoman Jasmine Crockett presented a constitutional argument that was both sharp and strong, shifting the direction of a major judiciary committee hearing in under 3 minutes. What was supposed to be an ordinary oversight session quickly turned into one of the most unforgettable constitutional showdowns in recent history. It started when Kavanaugh tried to lecture Congresswoman Crockett on the complexity of First Amendment jurisprudence. With all due respect, Congresswoman Kavanaugh said in a tone dripping with condescension, "These are complicated, constitutional issues that demand high legal expertise." Right after Crockett had challenged his recent decisions for inconsistency, suddenly, the entire room went quiet. Every person present sensed something critical was about to happen. What came next was a brilliant display of constitutional knowledge so well executed that not even an experienced justice like Kavanaugh had a proper comeback. If you're tired of watching capable women of color being brushed aside despite their legal expertise, you can't miss what happens next. Make sure to like and subscribe because Jasmine Crockett's reply didn't just leave Kavanaugh speechless. It exposed serious contradictions within the Supreme Court's recent rulings, sparking discussions among legal experts that will likely continue for many years. To really grasp why this face-off has caused waves throughout America's legal system, you need to know who these two people are and why their clash is much more than just a brief exchange. And if you appreciate this detailed breakdown, do us a favor, subscribe to our channel. We consistently bring you deep dives into crucial moments of US government proceedings, which many mainstream outlets barely cover. Your support helps us keep delivering this important content. Let's start with Supreme Court Justice Brett Kavanaugh, now 59 years old, who has served on the Supreme Court since his controversial confirmation in 2018, with degrees from Yale and a career on the DC Circuit Court of Appeals. Kavanaugh has long been seen as a textualist and originalist, following the legal philosophy of Justice Scalia. His rulings usually side with the conservative wing of the court, especially on cases involving executive authority, religious rights, and freedom of speech. Since becoming a justice, Kavanaugh has tried to project a more restrained, judicial persona, distancing himself from the heated drama surrounding his confirmation hearings. In his public talks, he often stresses how critical constitutional principles are and how the court should remain above political fights. The congressional oversight hearing that led to this clash centered around recent First Amendment decisions by the court, especially cases dealing with protests, political donations, and religious freedoms. These rulings have been highly debated, with critics claiming that the court has applied constitutional rules inconsistently based on the ideological leanings of each case. Now, enter Congresswoman Jasmine Crockett, who is currently serving her second term representing Texas. She brought a very different background to the table. Before Congress, Crockett had a notable career as both a civil rights lawyer and criminal defense attorney. A graduate of the University of Houston Law Center, she became known for fighting against voter suppression and defending protesters whose constitutional rights were violated. Since being elected, Crockett has quickly become known as one of the most legally savvy members of the House Judiciary Committee. Unlike many lawmakers who rely mostly on aides for legal matters, Crockett regularly shows an impressive command of constitutional law during hearings. Backed by her rich courtroom experience, what many didn't know before this hearing was that Crockett had recently finished an in-depth review of the Supreme Court's First Amendment rulings over the last 5 terms. Working alongside constitutional law professors from several top law schools, she uncovered concerning trends in how the court has applied so-called neutral principles differently depending on the case's subject and participants. The scene was perfectly set for conflict when the Judiciary Committee scheduled this oversight hearing on Supreme Court rulings and constitutional interpretation. These types of hearings are rare because justices rarely appear before Congress outside of confirmation hearings. However, with rising worries about the court's credibility and calls for ethics reforms, Kavanaugh and 2 other justices agreed to testify. Chairman Jim Jordan announced that each committee member would get 5 minutes to question the justices. Few anticipated that Crockett's turn would result in one of the most astonishing exchanges ever between a lawmaker and a Supreme Court justice, or that her constitutional skills would leave a sitting justice visibly uncomfortable. Struggling to defend his own legal reasoning, the House Judiciary Committee's hearing room was packed, with even more viewers watching via monitors in an overflow space. The air was tense but polite as Justice Kavanaugh wrapped up answering routine questions from senior committee members about the court's internal procedures and decision-making process. Then, the chairman announced, "A gentlewoman from Texas, Ms. Crockett, is now recognized for 5 minutes." Kavanaugh subtly adjusted in his chair, likely expecting the usual round of standard questions. Crockett, dressed sharply in a navy suit with a Constitution-themed lapel pin, calmly arranged her notes before starting. "Thank you, Mr. Chairman. Justice Kavanaugh, I appreciate you being here today," she began, her voice steady and formal. "I'd like to focus closely on the court's handling of First Amendment cases across various scenarios." She continued, "In your concurring opinion in Americans for Prosperity v. Zentro, you stressed that consistency in constitutional interpretation is key to upholding the rule of law. Do you still stand by that view?" Kavanaugh nodded, appearing relaxed with the opening question. "Yes, Congresswoman. Applying constitutional principles consistently is essential for the court's legitimacy and the rule of law." "I absolutely agree," Crockett replied. "With that in mind, let's examine how the court has actually applied the First Amendment in different cases over the last 3 terms. She opened a thick binder filled with case summaries. "In Zentro, which concerned donor disclosure for charities, you joined the opinion stating that even slight burdens on association rights require strict scrutiny." Then she flipped a page and continued, "But in McKesson v. Doe, dealing with protest organizers, the court allowed possible liability for the actions of others under a far looser standard." She looked directly at Kavanaugh. "Can you explain the constitutional logic behind applying different standards in these 2 cases?" Kavanaugh shifted in his chair, clearly unprepared for such a detailed comparison. "Those cases deal with different First Amendment settings. Congresswoman, donor privacy affects association rights in a different manner than protest activities." Yet Justice Kavanaugh, Crockett pushed. Both cases at their core concerned the same First Amendment right, freedom of association. In Zentro, the burden involved disclosing information to state officials under confidentiality rules. In McKesson, the burden was facing possible financial disaster for organizing a protest where someone else committed an illegal act. Why would the first situation trigger strict scrutiny, but the second receive only minimal safeguards? The room grew stiller as people realized this wasn't just ordinary questioning, it was a serious constitutional challenge. Kavanaugh's face changed from mild surprise to focused attention. "The specific contexts and government interests vary greatly," he replied. "The court's rulings recognize that First Amendment rules apply differently depending on each case's facts. Different applications, certainly." Crockett agreed with a nod. "But shouldn't the basic principles remain the same?" "Let me show another example," she said, flipping to another section in her binder. "In Kennedy v. Bremerton School District, you agreed with the majority, deciding that a public school coach had the right to openly pray during school events. The court stressed that even the possibility of indirect pressure on students was too uncertain to limit that expression." Without missing a beat, she continued, "Yet in City of Austin v. Reagan National Advertising, decided only months before, you supported an opinion allowing major limits on signed content, based on hypothetical worries over aesthetics and safety. Both cases weighed free expression against uncertain risks, but the court used completely different legal standards. What constitutional logic explains this difference?" By now, Kavanaugh's discomfort was obvious to everyone present. "Congresswoman, these are complicated constitutional topics that need in-depth analysis of prior cases and their contexts," he answered. "I don't believe they can be boiled down. 2 simple parallels." Crockett stayed composed. "I'm not making simplistic comparisons, Justice Kavanaugh. I'm questioning whether constitutional rules are being applied consistently, something you yourself have called essential for upholding the rule of law." She turned to another document. "Let me be clearer. In Americans for Prosperity, you wrote that First Amendment analysis must be rooted in history and tradition. But in Kennedy, the majority mostly ignored historical practices on church-state separation in public schools. That ruling, instead, focused on modern views about religious freedom. How do you explain these conflicting uses of history and tradition in First Amendment decisions from the same term? The hearing room was now completely silent. Many legal reporters were quickly writing, aware that Crockett was raising deep contradictions, often noted by constitutional scholars, but rarely addressed in congressional hearings. Kavanaugh, looking more uneasy, responded, "With all respect, Congresswoman, these are highly complex constitutional issues requiring expert legal judgment. Each case has distinct factors that the court must review based on legal text, history, and precedent." His condescending tone was impossible to miss. It proved to be a crucial mistake. Several committee members glanced at each other, sensing the insult and suggesting Crockett lacked the legal knowledge to discuss these matters. Crockett paused briefly, her expression steady. "Justice Kavanaugh, before I joined Congress, I spent 15 years arguing constitutional cases, including First Amendment lawsuits before the Fifth Circuit. I'm very familiar with how constitutional rules work in real-world practice." Without raising her voice or losing her calm, she continued, "The question isn't whether cases have different facts, they always do. The real question is whether the court consistently applies the same legal tests, regardless of who the speakers are or what their messages represent politically. The facts suggest that it does not. She then carefully proved her point, placing two Supreme Court rulings side by side on the display screen. In these two cases, both decided in the last two terms, the court applied strict scrutiny to protect religious speech, but only rational basis review to almost identical secular speech. The Constitution's text offers no such difference. Crockett next cited specific parts of James Madison's writings on the First Amendment and early Supreme Court rulings. The original meaning of the First Amendment, which you've said should be the guiding standard, did not create any ranking among types of speech. Religious or secular, conservative or liberal speech was supposed to receive equal protection, yet recent court decisions have clearly created favored types of speech. Her detailed and scholarly analysis was now clear to everyone present in the room. This was not political showmanship, but a deep constitutional argument, rooted in the text, historical context, and prior rulings, the same tools of interpretation that Justice Kavanaugh himself often supported. Kavanaugh tried to take back control of the discussion. "Congresswoman, the court aims for consistency," he began, "but every case brings its own unique elements." "Justice Kavanaugh," Crockett interrupted, respectfully but firmly, "I have found 7 major First Amendment rulings from the last 3 terms where the court applied entirely different standards of scrutiny to government actions that place similar restrictions on speech. The only consistent trend is the ideological leaning of the decisions, not the constitutional reasoning." She then presented a chart that listed these cases, their results, and the level of scrutiny used. When cases involved conservative religious speech, the court repeatedly applied the strictest scrutiny. However, when the cases concerned progressive political speech or workers' rights, the court switched to either a lower or intermediate scrutiny. "This," she said, "is not consistent constitutionalism. It's outcome-based jurisprudence." Her academic thoroughness was impossible to ignore. Even Republican members on the committee watched carefully, with some nodding, despite their usual disagreements with her. The depth of her constitutional review went beyond partisan divisions. Crockett pressed further. "Your own writings before you joined the court stressed that constitutional interpretation must stay neutral, no matter the subject. Yet the court's recent First Amendment decisions clearly show the kind of subject matter discrimination you yourself once opposed." She kept going, precisely pointing out examples of conflicting rulings in the court's recent record, always tying her points back to Kavanaugh's own previously stated judicial philosophy, her mastery of constitutional law and Supreme Court history was on full display in every case she cited and each carefully crafted question. By now, the entire mood of the hearing room had changed. What started as a normal oversight meeting had become an extraordinary lesson in constitutional law, led by someone clearly fluent in the highest levels of legal argument. Kavanaugh, who had appeared self-assured and slightly dismissive at first, now looked noticeably unsettled by the sharpness and accuracy of Crockett's criticism. The most dramatic moment arrived when Crockett opened her last binder and looked directly at Kavanaugh. "Justice Kavanaugh," she said, "I want to raise a specific point from your own judicial record that highlights this very issue." She continued, Before your confirmation, you wrote extensively about the need for viewpoint neutrality in First Amendment cases. In your 2012 Harvard Law Review article, you called it the cardinal sin of First Amendment law to treat similar speech differently, depending on who is speaking or how popular the message is. Kavanaugh's face shifted, showing clear surprise. Few in Congress knew about his academic writings before he became a judge. I'm familiar with that article, Congresswoman, he answered, cautiously. I'm glad to hear that, Crockett replied, because I have closely reviewed all 23 First Amendment cases decided since you joined the court. In cases involving religious speakers, corporations, or conservative advocacy groups, you voted for strict scrutiny every time. But in cases involving protesters, unions, or civil rights organizations with nearly identical constitutional arguments, you applied lower scrutiny in 91% of the cases. The entire room went silent as Crockett continued. This pattern directly conflicts with the principles you laid out in your Harvard article. It strongly suggests that the deciding factor in your First Amendment decisions isn't the Constitution's text, history, or past rulings, but rather the speaker's identity and the political slant of their message. She then displayed some excerpts from two of Kavanaugh's written opinions, delivered just 4 months apart. In these two opinions, you used completely different legal approaches to almost identical speech restrictions by the government. The only real difference between the cases was the identity of the speakers and their viewpoints. Visibly rattled, Kavanaugh adjusted his tie. Congresswoman, he responded, judicial opinions address the specific circumstances of the cases before the court. Different settings demand different legal tests. Different settings, yes, Crockett responded, but not different constitutional principles. Your own writings clearly say that, while applications may change, the basic constitutional rules must stay consistent, no matter who's speaking or what is being said. She paused, then delivered the decisive statement of the hearing. Justice Kavanaugh, the First Amendment doesn't just protect popular voices or powerful groups. It doesn't include exceptions based on ideology. The same constitutional protections must apply whether the speaker is a large corporation or an ordinary protester, a religious group or a labor union. When the court uses strict scrutiny to protect speech it agrees with, but then applies weaker tests to speech it disfavors, it damages the very neutrality that gives the court its legitimacy. Kavanaugh, clearly caught off guard by the depth of her argument, attempted to redirect. The court aims to apply constitutional principles fairly. Congresswoman, reasonable people can disagree about how they're applied, he said. Reasonable people certainly can disagree, Crockett replied. But principles themselves shouldn't change just because of who is speaking. That's the heart of viewpoint neutrality, a standard you've personally supported in your writings, but which your voting record hasn't always followed. By now, many phones in the gallery were raised, recording what had become a landmark. Exchange legal reporters from major outlets were typing quickly, aware that this wasn't just political spectacle, but a major constitutional challenge with lasting effects on First Amendment law. Kavanaugh shifted again, his famously calm appearance clearly breaking down. Congresswoman, he said, you're combining different categories of First Amendment precedent to make it seem like there are contradictions. I'm not mixing anything up. Justice Kavanaugh, Crockett answered with calmness. I am directly citing your own rulings and showing their inner contradictions. For instance, in Americans for Prosperity, you stated that even slight restrictions on association must pass strict scrutiny. However, in Cedar Point Nursery, decided in the same term, you supported an opinion using rational basis review for a significant limit on labor organizing, which also counts as association safeguarded by the First Amendment. She picked up another document and continued, now, let's talk about your repeated mentions of history and tradition in First Amendment cases. In Kennedy, you supported an opinion that nearly ignored the long-standing tradition of restricting religious speech by school officials. But in Bonta, you relied heavily on historical practices as decisive. It appears the principle changes depending on the case. The committee chair looked at the clock and signaled that Crockett's time was almost finished. Crockett nodded in understanding and delivered her closing remarks with sharp accuracy. Justice Kavanaugh, she said respectfully, I honor the court as an institution and your place within it. My concern lies with how constitutional standards are applied unevenly based on who is speaking and what they are saying. When the court uses strict scrutiny to protect favored speech but applies weak scrutiny to disfavored speech, it weakens the First Amendment's main purpose, defending all speech, no matter its popularity or the speaker's influence. She looked straight at Kavanaugh. The biggest danger to First Amendment rights isn't a particular speech restriction, she said firmly. It's the belief that constitutional protection depends on who you are and what you say, instead of focusing on the government's action itself. If the court wants to preserve its reputation as the defender of constitutional freedoms, it must apply its methods consistently, regardless of the speaker's identity or the message's political leanings. The hearing room quickly filled with murmurs. Some committee members, including Republicans, known for their respect for legal expertise, nodded in agreement. Reporters scrambled to take notes. Kavanaugh sat in shock, clearly caught off guard by such a precise and thoughtful critique of his constitutional record. A senior Republican committee member leaned toward his Democratic colleague and whispered, "I don't agree with her politics." But that was a masterclass in constitutional reasoning. She just uncovered real contradictions in their latest rulings. Chairman Jordan, aware of the moment's historic weight, said, "The gentlewoman's time has ended, but the witness may reply." Kavanaugh, regaining his composure, responded, "The court always tries to apply constitutional rules fairly across all cases. What may look like contradictions often come from the complex mix of past rulings and the unique facts of each case. I respect the Congresswoman's views and her clear preparation for today's hearing." His reply, though polite, clearly avoided addressing any of the exact inconsistencies Crockett had pointed out. The Supreme Court Justice, long recognized for his detailed and careful opinions, had been left nearly speechless by the Congresswoman's exact and deep questioning. As the hearing moved to the next speaker, cameras caught several senior members walking over to Crockett with visible admiration. One veteran Republican lawmaker, who once clerked on the D.C. Circuit, was overheard saying, "That was the most thorough constitutional analysis I've heard in this committee in 20 years. The impact of the Crockett-Kavanaugh exchange was swift and widespread. Within hours, video clips of their debate had spread like wildfire across social media. The hashtags #ConstitutionalClash and #CrockettSchools Kavanaugh quickly trended nationwide, with the footage earning more than 30 million views within a single day. Legal experts from across the political divide weighed in on the substance of the moment. Harvard law professor Lawrence Tribe tweeted, "In 50 years studying constitutional law, I've rarely seen such a sharp and well-grounded challenge to the court's First Amendment reasoning." He added, "Congresswoman Crockett raised serious inconsistencies that merit close review by the court. Even conservative legal figures acknowledged the power of her arguments." Former federal judge J. Michael Luttig wrote, "Although I usually support the court's recent First Amendment decisions, Congresswoman Crockett's critique of inconsistent scrutiny standards raises fair concerns about principled constitutional interpretation. Her questioning was unusually deep and deserves full consideration." Major news outlets soon shifted from focusing on the personal tension of the hearing to examining the legal issues Crockett had brought forward. The New York Times published a detailed analysis titled, "A Tale of Two Scrutinies: The Court's Conflicting Approaches to First Amendment Rights." The article heavily featured Crockett's arguments, noting that many constitutional experts found her points about varying legal standards convincing. CNN hosted a panel of First Amendment scholars who generally agreed with Crockett's assessment. "What makes this moment so extraordinary," said one conservative legal expert, "is that she wasn't making political attacks. She highlighted real inconsistencies in judicial reasoning, points many of us have noticed but rarely see discussed so openly in Congress." Within just days, law schools nationwide asked permission to use the hearing footage for teaching constitutional law. Georgetown Law Center announced a new conference titled "Scrutiny and Consistency in First Amendment Jurisprudence." Directly inspired by the debate, the Yale Law Journal even commissioned a special issue exploring the scrutiny differences Crockett had highlighted in her questioning of Justice Kavanaugh. Observers noted that the hearing had become a serious professional challenge for Kavanaugh. Court watchers remarked that his dismissive attitude toward Crockett's early questions, followed by his inability to answer her clear and well-prepared critique, had damaged his reputation as a consistent constitutional thinker. The Washington Post released a detailed piece titled "Kavanaugh's First Amendment Jurisprudence Under Scrutiny." exploring whether his voting record truly reflected the contradictions Crockett had pointed out. Legal websites and discussion boards were buzzing with debates over what was now being referred to as the Crockett test, whether a justice applies an equal level of constitutional review, no matter who the speaker is or what the speech's ideological leanings may be. Law professors noted that students had begun using this method of analysis to review Supreme Court rulings involving different constitutional areas within the court itself. Reports suggested that this back and forth had sparked internal debates about consistency in legal doctrine. According to unnamed court officials who spoke with The New Yorker, several justices had quietly admitted that Crockett's analysis highlighted actual contradictions in the court's recent First Amendment decisions. Even some conservative members of the bench were said to be uneasy about the growing perception that constitutional safeguards changed depending on who the speaker was. According to insiders, some justices felt that this exchange had exposed weak spots in the court's handling of First Amendment matters. One source told The New Yorker, "When a lawmaker can clearly point out such obvious inconsistencies in scrutiny, it raises real concerns about whether the court is truly sticking to neutral constitutional principles." For Congresswoman Crockett, the hearing marked a turning point in her national recognition. Universities throughout the nation invited her to speak about constitutional interpretation and Congress's oversight role. The American Constitution Society requested her to deliver the keynote speech at its annual gathering on neutral principles and First Amendment law. Prominent legal groups representing women and minorities praised her performance as a crucial example of why it is essential to include diverse voices in constitutional debates. The National Bar Association even created the Jasmine Crockett Prize for Constitutional Analysis, awarded to law students who excel in identifying inconsistencies in constitutional law. What Congresswoman Crockett displayed wasn't merely personal brilliance, said the Dean of Howard Law School in a widely circulated op-ed, but also the importance of having perspectives from people who have actually fought constitutional cases for everyday citizens. Her hands-on background as a civil rights lawyer gave her a practical understanding of the real-life impact of doctrinal inconsistencies, an aspect that is often overlooked by purely academic scholars. Possibly the most important effect was the shift in how Congress handled its oversight of the Supreme Court. Legal analysts began discussing what they called the Crockett model of congressional questioning, an approach rooted in serious constitutional analysis instead of partisan talking points or personal criticisms. A Pew Research survey conducted 2 weeks after the hearing revealed that 71% of Americans believed Supreme Court justices should be required to explain any apparent inconsistencies in their constitutional rulings. Remarkably, this belief cut across political divides, with large numbers of both Republicans and Democrats supporting stronger demands for consistency from the court. 3 months after the hearing, the influence was still felt when the Supreme Court heard arguments in a major First Amendment case concerning protest rights. Observers noticed that multiple justices, including Kavanaugh, asked questions focused specifically on the uniformity of scrutiny standards across different types of speakers' questions that directly mirrored Crockett's earlier critique. When the court announced its ruling 4 months later, legal experts were surprised to read Kavanaugh's concurring opinion, which carefully addressed the need for consistency in First Amendment rules across varying cases. While he didn't mention Crockett by name, his opinion acknowledged that the court must diligently apply the same level of review, regardless of who the speaker is or how popular the message may be. A core First Amendment value that, he stressed, must guide every decision in this field. Kavanaugh's shift on First Amendment consistency is remarkable, wrote a constitutional scholar on SCOTUS blog. His current focus on viewpoint neutrality and consistent standards marks a significant departure from his past judgments. Although justices rarely admit what has influenced their thinking, this evolution suggests that thoughtful critiques from Congress can, in fact, impact constitutional rulings. 6 months after the hearing, Crockett introduced the Judicial Transparency and Consistency Act, which would require the Supreme Court to clearly state and justify the level of scrutiny used in constitutional cases. To many people's surprise, the bill gained bipartisan support. Several conservative legal groups endorsed the proposal, seeing it as a step toward principled constitutionalism and judicial accountability, particularly for Americans from communities that have traditionally been underrepresented in the legal system. The Crockett-Kavanaugh Debate became a powerful example of how strong preparation and legal expertise can break through bias and assumptions. Social media was flooded with posts from young women of color, many saying they were inspired by seeing Crockett hold one of the country's most powerful legal authorities accountable through pure constitutional reasoning. Watching Congresswoman Crockett dissect such complicated constitutional issues showed me how far you can go if you master your craft, wrote a first-year law student in a viral TikTok clip. She didn't shout or get emotional. She simply laid bare the contradictions in their arguments by using their own language and principles. 1 year after the hearing, the Georgetown Law Journal published an in-depth review of the Supreme Court's scrutiny standards in various First Amendment cases. The article confirmed many of the patterns Crockett had previously identified and has since become required reading in constitutional law courses across the country. As for Justice Kavanaugh, even though he never publicly admitted being influenced by the hearing, court watchers observed a clear shift in his First Amendment opinions. His later writings reflected a stronger commitment to applying consistent scrutiny standards, with one law professor noting Kavanaugh's current First Amendment approach shows a sharpened awareness of the need for principled consistency across different categories of speakers, a notable change from his earlier rulings. Ultimately, the clash between Crockett and Kavanaugh went beyond a fleeting courtroom exchange. It turned into a landmark example of constitutional accountability and the need for consistent constitutional principles. Many law schools now use this case as a model for effective congressional oversight and as proof of the importance of genuine constitutional discussions between branches of government. Perhaps the most enduring impact came with the release of a new constitutional law textbook that included a chapter on scrutiny standards, which opened with a recounting of the Crockett-Kavanaugh exchange. The chapter concluded with this message: "This episode reminds us that constitutional interpretation grows stronger, not weaker, when subjected to tough scrutiny from co-equal branches of government. When justices are called upon to explain inconsistencies in their rulings, the resulting dialogue not only strengthens the court's credibility, but also clarifies constitutional law." If this story of constitutional expertise and principled analysis moved you, click the like button and subscribe for more stories that show how knowledge and preparation can challenge power. Share your thoughts in the comments. Have you seen other moments where serious legal expertise improved our constitutional debates? Because when we understand our rights and demand fair protection of them, we all become stronger citizens of our constitutional democracy.